I wanted to mention very, very briefly that it is for the first time that ILA has come to Hyderabad, to Ramoji Film City, which is such a great pleasure. The credit for that goes partly to BVS and Raju, senior advocate, who at our last conference in Tijara in Rajasthan said that you should come to Hyderabad. And I said, why not? And then Sri Shamala took charge, and she helped us in many, many ways in making this happen. And thanks to Ramoji family, they made sure that we get the best of the way forward to make that happen. We have great privilege to have amongst us many, many of stalwarts of the insolvency industry from the country and from overseas. And obviously, we're very honored to have with us our chief guest of the day, Honorable Justice N.V. Ramana, the former Chief Justice of India. And he has a very long, illustrious career. And because I want to be sure that I don't miss out on anything important, I penned a note, so I'm going to just slip across and take that. A very eminent lawyer, Honorable Justice Ramana was appointed as Acting Chief Justice of the Andhra Pradesh High Court in March 2013. He was elevated as the Chief Justice of Delhi High Court in September 2013, where he served till February 2014 before his elevation as a judge of the Supreme Court of India, which is the apex court of the country for the benefit of those who are from outside India. He superannuated on 26th August 2022. But in his tenure as the Chief Justice of India, Justice Ramana made mark as was expected of him, as he had done while as serving as the acting Chief Justice of Andhra Pradesh High Court and as Chief Justice of the Delhi High Court. He authored many notable judgments, and I would take the liberty of mentioning a few in a minute. But one of the remarkable aspects of his tenure as the Chief Justice of India was that he was appointed at the time when we were almost in the midst of COVID-19. There was a chaotic time for everyone, including the Supreme Court. And he was, in fact, as many people say, the second COVID 2019 CGI. It was Justice Ramana who launched an app to provide the media with virtual access to the hearings. He launched a software to transmit court orders swiftly and securely through electronic mode. There's only one brief aspect that I was mentioning about his very illustrious tenure as the Chief Justice. He authored many judgments, and I'll take the liberty, as I said, of mentioning a few, although the list is very long. And then, of course, I'll mention a little bit about his contribution in the insolvency aspect as well. One of his notable judgments is Anurad Bhasin versus Union of India, where a three-judge bench ruled upon the internet shutdown in Kashmir in 2019. Writing the majority opinion, he stated that the right to trade over the internet was a fundamental right under the right to freedom of speech and expression. He further held that the internet cannot be suspended for an indefinite period. The Supreme Court established the test to apply when an accused claims mental unsoundness as a defense under Section 84 of the Indian Penal Code, as it then was. Now, of course, it is known by a different name. That was, again, a very important judgment. There are many, I can go on, the list is endless. But his contribution to insolvency is also remarkable, because the insolvency law, that is the IBC, was at a very nascent stage in 2020-21 when Justice Ramana became the Chief Justice. And we needed some top quality members to the National Company Law Tribunal, the institution that is responsible for many of you who are not from India, the Bankruptcy Tribunal, which has a great role in ensuring the success of the IBC's implementation. And Justice Ramana took very keen interest in identifying and selecting the right members. And I say this because the committee that selects and appoints, eventually recommends for appointment, it comprises of 2 Supreme Court judges, which are nominated by the Honorable Chief Justice. And therefore, he had taken keen interest through those judges and even directly to ensure that the right kind of members are appointed. And of course, there are a lot of things that I know, which of course I cannot mention here, where I have personal knowledge of how keenly he wanted to make sure that IBC becomes a great success after its rollout in 2016. Sir, we are deeply honored by your presence here and grateful for having taken out the time. We know that we have a very busy schedule, your arbitrations and your other commitments, but we truly appreciate, and particularly because your engagement and interest in the insolvency as a subject, we thought that it'll be a great privilege for us to be able to have you here and hear you. So may I request you to please join us on the stage. Our second guest for the evening is Mr. Mark Bloom, a personal friend, chair of the International Insolvency Institute, a legend, a veteran in the field of insolvency, lives in a very different part of the world, Miami, and globe-trotting all the time. Met him in different cities, and I thought we should bring him to Hyderabad as well. And Mark, I'm not going to read out your CV because it's as illustrious as it can be for an insolvency specialist, turnaround specialist, but we'll get to hear from you in a number of sessions where I'm sure you'll reflect on your experience and views. May I request you to please join us on your stage. Before I start with what has been a tradition at all ILA conferences, where I share with you what we have been doing over the last 1 year and what is it that we intend to focus on going forward, I wanted to take a moment to remember 3 personalities who we have lost over a period of time and who were deeply associated with ILA in one way or the other. The first person, if you can move, okay, I have the control, I remember this. Mr. Patrick Ang from Singapore. Patrick was a dear friend, but a legend in the world of insolvency. He was ILA Emeritus Fellow. We lost him last year, and it was not just loss of a dear friend or an ILA Emeritus Fellow, it was a loss to the entire insolvency industry globally. Patrick was a dear friend to many of you in this room. He was one of the admirers of the work that ILA does, and also a great supporter of insolvency industry in India, and was always willing to do whatever he could within his means to support us. Mr. Arun Jaitley, again, an ILA Emeritus Fellow, someone who we owe the Insolvency and Bankruptcy Code to. not only as someone as finance minister gave us this law, but also from the time when the demand for an insolvency policy happened in 2001 in particular, he has been at the forefront in championing the cause of insolvency reform. We lost him in 2019 after having driven the implementation of the insolvency law very effectively, always remaining in command of what was happening, introducing quick amendments. Many of us have worked very closely with him, and we still miss him very dearly. And I was very privileged that last week a book on the life of Arunji, the life and legacy of Arun Jaitley, was launched by one of his dear friends, Shri M. Venkaiah Naidu ji, the Honorable Vice President of India, in the presence of a very distinguished gathering of Mr. Jaitley's friends, politicians, bureaucrats, and of course Dr. Bibek Deb Roy, to whom we owe this institution, Insolvency Law Academy. It was again in COVID, during the COVID, just after that Dr. Bibek Deb Roy, I and a couple of other economists in the Prime Minister's office conceived Insolvency Law Academy, because we felt that given the aftermath of the COVID, given the geopolitical developments that are taking place rapidly, we need an independent thought leader, an independent think tank, an independent institute of excellence, which can continue to apprise the government and the other institutions in the country on the developments that are happening and guide in formulating the most effective policies to deal with developments that may take place in the future. We lost him also a little over 1.5 years back, but he was again not just one of the co-founders of ILA, but someone who was a personal friend, guide, and philosopher to me. I just want to very, very briefly mention about a few areas in which we have worked in the past and will continue to work in future. Some of it has received great amount of traction, and some we are hoping will receive the attention of the policymakers and the market in future. Climate change and insolvency, a subject not many economies or countries are willing to talk about. It's a very sensitive subject given the geopolitical dimensions that are associated with it, and the compromises that especially the emerging markets are expected to make, adjustments they're expected to make to accommodate the climate change policy, which obviously they apprehend will slow down their economic growth. And these are all very aspirational economies, including India. India in particular, which aspires to become a developed economy by 2047, would obviously want to be very careful in terms of the decisions that they take. And it's also about a level playing field at the international level when it comes to implementing the climate change policies. But I have to say that notwithstanding that kind of excitement around it, we have authored a paper. It's a thought paper. It's not really a policy recommending paper, but it's like a thought paper, which we have submitted with the Prime Minister's office, and they're studying it very, very keenly. And we are hoping that in times to come, we will be able to get the kind of attention that is needed on this topic. I won't talk about all of it, but I want to talk about individual insolvency in particular, although I was hoping to save it for the last slide, that this is one area we haven't really made any progress at all. This part of the law is sitting on the statute waiting to be implemented. And it's been a decade, but we haven't really seen this being notified. But there is thankfully some attention on that, and I'll save it for the last slide because that sort of dovetails into what I mentioned in the beginning, that we are looking at some of the topics in future. Cross-border insolvency is something that we have relentlessly over the last 10 years lobbied with the government, trying to persuade them to implement the UNCITRAL model on cross-border insolvency. Thankfully, in the bill that was tabled in the Parliament on 12th August to amend the IBC, we have found an enabling provision for the implementation of the UNCITRAL model law. But still was very lacking in terms of how we, at least I personally as a lawyer, thought it needed to be in the statute, because many of those who are lawyers in this office, and of course Honorable Chief Justice Ramana would agree that substantive provisions of the law, substantive provisions of the cross-border framework, we thought very, let's say almost very strongly that it needs to be in the body of the statute rather than be left to the rules. And thankfully, we were able to persuade this select committee of the Parliament, which has agreed with our recommendation, and they have in their committee report suggested that it should be specifically mentioned in the substantive provision in the code that 3-4 areas: the jurisdiction of the NCL to recognize foreign judgments, the right to or the power to decide what proceeding, whether the foreign proceeding or the Indian proceeding should be considered as the main proceeding and which as non-main proceeding, the jurisdiction to grant interim relief, because that is not a jurisdiction that exists at the moment in the scheme of the court. It can only be on admission that moratorium can trigger. And the fourth is the cooperation with the courts in foreign jurisdictions. And we are hoping that with the new bill, the amended bill that is going to be tabled in the Parliament in a few days, will likely have that provision. I also want to mention about MSME insolvency very briefly, because that's one area where we know that we haven't really been able to produce very effective results. The pre-packs that were introduced for the MSMEs haven't got any ownership from the market. Only a handful of cases have been filed. There are a number of reasons given for that: complexity of the statutory provisions, too complex regulations. But in my view, the problem lies elsewhere. And that is that 96% of the MSMEs in India are proprietorships or partnerships. In fact, 93% are proprietorships, and just about 3% are partnerships. And I'm talking about unregistered partnerships, not limited liability partnerships. And therefore, 96% of the MSMEs in India are individuals in another avatar, to which the IBC doesn't apply, because the IBC only applies to the companies incorporated under the Companies Act or limited liability partnerships under the Companies Act. And therefore, it is open to a very little segment component of the MSMEs. And fortunately, this has again got a bit of attraction, and I'll talk about that. Bank insolvency. Bank insolvency, again, very, very quickly, is what we've been focusing on. We know that the law that was tabled in the Parliament in 2017, the bill, was withdrawn in 2018 because of the controversies it generated. But since then, the UNIDROIT, on the demand of the international community, has been working on a draft model law for medium-sized banks and financial institutions, which has been approved last year in May by UNIDROIT as well as the General Assembly. And therefore, it is expected that now the member countries will adopt this model law in one form or the other in their domestic laws. And fortunately, the Reserve Bank of India was part of the working group that was formed to frame that model law, and we're also fortunate that Insolvency Law Academy was invited as an observer, and I had the privilege of attending many meetings and contributing on that on behalf of the Government of India alongside the Reserve Bank of India. One more topic very quickly is the municipal debt restructuring. Again, this was a topic which everybody's asked us as to why is it that you even want to talk about it. There is so much more to do on corporate insolvency, and you're talking about MSME at such early stage of ILA's formation, because we are only in our 5th year. And that's something which I got great support both from Dr. Sahu and from Mr. Pramod Rao, who's also here with us, who was then the Executive Director of Securities and Exchange Board of India, SEBI, India's market regulator, the capital market regulator. And he felt that there was a great potential for the Indian municipal corporations to list their bonds on the stock exchange and raise money from the market, because it is so uncertain to depend on the state governments for funding, and there is no other access to finance available for the municipal corporations. And the municipal corporations are low-hanging fruit for India, which is aspiring to become a developed economy by 2047, because they can serve as engines of growth and drive economic growth in many cities beyond traditional, typically Delhi, Mumbai, Kolkata, Chennai, some others that we have looked upon for driving growth and infrastructure and improve the ways and quality of life of people. That report is done, although we are still brainstorming on it. A draft was presented at the last conference, and we'll hear from Pramod a little bit on that as well. And I'm so delighted to also inform you that Niti Aayog has agreed, and for the benefit of those who may not be familiar with Niti Aayog is the think tank of the Government of India, and they have decided to examine this issue more closely. And I'm hoping that this is something that we will talk a little bit more about going forward in our conferences and in other discussions. Very, very quickly on the partnerships that we have been able to build over the last 4.5 years. Some of the leading institutions of the country and beyond, and that's one reason which has contributed to our rapid growth as an institution, because our partners have contributed their resource, their talent, and their bandwidth to us, because we were an absolutely new institution. Some of the reports where we have made impact already: hybrid insolvency resolution process, where we work with Ernst & Young and Chandiok and Mahajan. Pooja is here. Our report has been accepted in a way where government set up a committee, expert committee, based on the recommendations of the expert committee. We today have in our law creditor-led insolvency resolution process introduced in the draft bill that was tabled in the Parliament on 12th August. We were able to sort of also persuade the aircraft protocol, the Cape Town Convention, to be implemented, because we produced a thought paper on that. We have also highlighted in our subject the traction between the maritime law and insolvency law, given that India's shipping industry is very rapidly growing, and it's important that we also align the international maritime law with the insolvency standards. Some of the other, I won't really bother you too much on this. This I have already mentioned in a way, but if I may very briefly mention that it is a privilege for ILA that we've been invited as observer by the UNCITRAL to the Working Group 5 meetings, which is a great privilege, not just for ILA but for the country as well. Two subjects that we are working on at the moment. One, we have already spoken about, the municipal debt restructuring, but the failure, redemption, and dignified exit, as to how Indian cinema has treated failure ever since we started making films in India, because cinema is a reflection of society, it is a mirror of society. And Asha Batra, she is the founder of Indian Cinema Heritage Foundation. She's a film historian. She's also my wife. She will be making a presentation as a last session today on how Indian cinema has treated insolvency, bankruptcy, or failure per se, and how it has evolved also, and how we need to therefore use this medium and other medium to educate people about the change in mindset going forward. Insolvency Scholars Forum is our capacity to build, is our initiative to build capacity amongst the academics of this country and to mentor young scholars so that we have enough academics and scholars available going forward to teach at all levels of pyramids in the country. And the gentleman who has really contributed very significant to this, Dr. Eugenio Vakari, is also amidst us. Eugenio, if you could just raise your hand. And yeah, thank you so much, because I really value your contribution. Laura is not here, but many of you from around the world who have been working with us. And now Jonathan, may I request you to raise your hand as well. Dr. Jonathan as well, who chairs the Emerging Scholars Group and has been mentoring the young scholars in this country in terms of how to sort of deal with the complex subjects of insolvency. I'll skip this. I just want to mention that we also have a MOU with Arun Jaitley Foundation, with which we hope to establish a mediation center as soon as the mediation council is established and the accreditation program is notified by the government, where we are hoping that together with the two institutions will work in creating capacity in the area of mediation and insolvency law. Just want to very, very quickly mention that we run, as you many would know, that the first international competition on short stories on insolvency. This is a literary initiative where we encourage those who have literary streak and are interested in literature to write short stories on the subject of insolvency so that we can get educated about how the society perceives insolvency. This is the third edition. The prizes will be announced this year for the winner, and we get remarkable stories, and we'll publish a book now of the stories that are received over the last 3 editions. The announcement for your benefit is that from next year we are renaming the institution in this initiative in the honor of and the memory of Patrick Ang. It will be now called as Patrick Ang ILA International Short Story Contest, and we have the approval of the family in Singapore to do that. I'll skip this. Just want to mention that we have an insolvency research center in the name of former judge of the Honorable Supreme Court, Justice D.P. Wadhwa, because he was one of the founders of Insol India, one of the organizations which champions insolvency reform. We've been working in Sri Lanka, Nepal, other jurisdictions. I'll skip that. Our conferences in the past, again, I'll skip that. Many people who have have in some way or the other encouraged us by talking about it. That's our board. That's Emeritus Fellow, Justice Nariman, Mr. Jaitley, Dr. Bibek Debroy, Justice Sanjay Kishan Kaul, T.K. Vishwanathan, who was the chair of the Insolvency Committee, and many others, including Justice Kannan Ramesh, who was appointed as the ILA Emeritus very recently. Chief Justice Suryakant granted the citation, and Dr. Sahu also was inducted as the Emeritus Fellow. Just 3, and I'll take only very quickly 2 minutes. I know that I've surpassed my time, but I took the liberty because we got some extra time available just since Justice Sikri is not here. But that's my last slide. I spoke about personal insolvency. I just want to mention that next 1.5 to 2 years, we're going to focus on this particular topic of personal insolvency because the Government of India is hoping to implement this law in 2027. And we've been requested to create as much literature as possible to understand this subject, the complexities of it, especially from the point of view of as to how can we create in this country, instead of job seekers, job creators. How do you produce young entrepreneurs? And for young entrepreneurs, to tell them that risk-taking is an integral part of entrepreneurship, and so is failure. And not to be afraid of failure, but at the same point of time, you need policies that don't ridicule failure, then don't stigmatize failure, and encourage people to take a second chance and provide a dignified exit at the same point in time. Modified universalism is something which we all know because of the geopolitical developments that are taking place, which we all read and hear. I don't want to talk too much about it. We have a dedicated session on that. This is again is something which inevitably will be part of the attention of the policymakers and those who work in the development of the insolvency policy outside of the government. And one of the key aspirations that we have as an ILA is that we now need to move away from the recovery and restructuring to turn around. Last 10 years, our focus has only been recovery and restructuring. But restructuring also has been primarily recovery. But time has come now, we have to turn around the assets that are not contributing optimally to the economy so that these assets can go back and churn into the economy and produce and contribute to our GDP. So thank you so much for your attention. This is the ILA Advisory Board, and all the progress that we have made is with the guidance of many eminent people on this board, and of course amongst them we have Dr. Sahu present in the room. We have Shisha Malla present in the room, Justice Shisha Malla. James Spiragon, I can't see him in the room, but he's in the hotel, I know. And many others who are joining virtually but may not be here physically. So thank you so much for your attention. I'm going to now invite Mr. Mark Bloom to say a few words, and then I will take the privilege of inviting our chief guest.
Good afternoon, everyone. Thank you, Sumant, for the kind invitation to join you here in Hyderabad, for the overly flattering description of my background that you offered before, and most of all, for the energy, drive, and passion that you bring as you articulate, develop, and focus the efforts of ILA on the reform and advancement of insolvency laws in India and beyond. I bring you all greetings from the Insolvency Institute, which I have the great pleasure to serve for 1 year as chair. I'm going to talk a little bit about III, as we call it, its mission, its place in the global insolvency world, its work and support for the development of local and cross-border insolvency regimes around the world. As part of that work, we very much would like to support and contribute meaningfully to the important work of ILA and so many of you in furtherance of the growth and development here in India, the world's fastest growing and most dynamic economy, as it pursues Viksit Bharat over the next 2 decades. The International Insolvency Institute is a global nonprofit limited membership organization of approximately 450 members from more than 60 countries, dedicated to advancing and promoting insolvency as a respected discipline in the international field. Our membership includes leading judges, academics, scholars, legal and financial advisory practitioners, representatives of financial institutions, government and regulatory bodies, all of whom must be nominated for membership by their peers after at least 15 years of experience in the field of insolvency. III is one of several leading organizations that seek to advance and promote the growth and development of insolvency law and systems around the world. Many of you, no doubt, are already familiar with the expansive work and footprint of Insol, a much larger open membership organization that is brilliantly represented here by its dynamic Chief Executive Officer, Scott Stewart, and by at least 2 of its elite past presidents, including James Spray Reagan and, of course, your own Sumant Batra, the first Insol president from the continent of Asia. It was Insol that ignited my own personal interest in cross-border insolvency when I attended my first annual meeting in London in the year 2000. I owe so much to Insol as a catalyst from my mid-career shift toward international work, and to this day, I seek to support its outstanding work in any way I can and urge all of you to do the same. III sets out to occupy a different niche within the array of international insolvency organizations. III, I should say, being the term that we fondly use to describe the International Insolvency Institute. Through our exceptional membership of seasoned and experienced insolvency practitioners and experts, and in furtherance of that process, the comprehensive array and range of developmental and educational alternatives initiatives undertaken by ILA, along with the sense of urgency it continues to inject into the implementation of the Insolvency and Bankruptcy Code, are unique among insolvency-focused in-country organizations that I have observed anywhere. As its accomplishments multiply and its good work is promoted actively around the world, I dare say that ILA will become a model for how insolvency professionals in other developed and developing nations can light the fire for advancement and reform of insolvency systems to meet the needs of their own evolving economies. On behalf of III, I'm honored by the opportunity to join all of you here in Hyderabad to observe a portion of the work of ILA firsthand and to learn more about the dynamic growth of India, its economy, and the legal and financial systems that will help to drive and direct that growth. At the same time, I invite all of you to become active parts of the international insolvency world. You might begin, if you so choose, by visiting our III website at iiiglobal.org. Access our online materials. Take advantage of our podcasts and webinars on a variety of topics of great interest. And hopefully in the not-too-future, attend one of our annual or regional meetings at a rotating series of venues around the world. All of those meetings are open to our members and to non-members as well, and in particular, our upcoming annual meetings in June of each year are in Montreal, Canada, in June of 2026, and Dublin, Ireland, in June of 2027. I'm delighted to be here in Hyderabad at Sumant's invitation, and excited to share and exchange ideas and perspectives with so many of you whom I will have the pleasure to meet for the very first time. On behalf of the International Insolvency Institute, I'm most excited to express our strong support for the efforts of ILA and all of you in pursuit of the vision of Viksit Bharat. Thank you all so much, and I look forward to several enjoyable days with you.
May I now, without much ado, request our Honorable Chief Justice, Chief Justice N.V. Ramana, former Supreme Court Chief Justice, to make his place.
Thank you. Dear friend and the President of Insolvency Law Academy, Sumant Batra, and my dear law students, I'm very happy here to be in your midst to attend this 4th annual conference of Insolvency Law Academy. I must thank Mr. Batra for extending this warm invitation. Apart from his professional work as a leading lawyer, insolvency lawyer, he is an author and policy expert. Apart from that, he is a cinema enthusiast. It is therefore remarkable and a coincidence that he has chosen a place, Ramoji Film City, to host this conference. Ramoji Film City is a landmark institution, and it's a defining milestone in India's cinematic journey. I congratulate the Insolvency Law Academy for creating an environment and a good institution that has become a intellectual hub about the insolvency laws and policy and other remarkable work within a short span of time. Before I begin whatever I want to say a little my background, because Mr. Batra has said that I am a judge and lawyer and all that. But particularly, this is a international conference. Most of you are having a background of business laws, economy, economics, etc., etc. But my background is I am son of a farmer, came from a village in a remote village in Andhra Pradesh, and I studied in my mother tongue till I think up to degree. I started my law in English only after reaching university. We traveled across the country to select NCLT members those days. Same story. Company secretary or corporate affairs secretaries, they used to be the members of the committee. After traveling Bombay, Chennai, Calcutta, etc., we select some candidates, and they will say that these candidates are not good, their antecedents are not good, they are not experienced. So they keep the file for almost one year. So with the big fight, we got appointed some people in the first batch. And after that, Justice Gogoi was elevated as Chief Justice. I am the chairman of the committee, and with me, Justice Sapre. That is also another story, same story, repetition, going across the country, selecting people, after years getting some members' appointments. Thereafter, my elevation, I appointed Justice Suryakant as President Chief Justice, as chairman of the committee, and Justice Maheshwari. I think now the story is not that impressive. This is what I heard. So, by and large, what I want to say is, even though the law was introduced with a lot of enthusiasm, it is not up to the expectations of the progress. This much I can say introductory comment. But I have a lot of other things which I want to say now. End of the thing, if possible, we can discuss how to improve further and how to make effective this insolvency laws in India. I welcome all the delegates who come across the world, and I hope you get a chance of enjoying and exploring the city of Hyderabad, a wonderful city. You can have very good food and good cuisine and historic places, and you can really enjoy this Hyderabad city and its hospitality also. We have all read the scene in the Shakespeare's Merchant of Venice, where a money lender stands before a judge and demands for what the law promised him, that is a pound of flesh for an unpaid debt. The contract was clear and there was an admitted debt, and yet enforcing the contract did not feel just. That moment captures the essence of insolvency law in its earliest and most honest form. Insolvency was not seen as an economic consequence, but a social, moral, and deeply humane situation. Over time, as economies become more complex, insolvency law also become more elaborate, structured, and focused. What initially began as a question of moral obligation transformed into a framework for economic community, orderly distribution, and collective resolution. Yet, the underlying question remained unchanged. How does a society treat those who fail? Modern insolvency law recognizes that failure is not always the result of moral wrongdoing, but also of risk, uncertainty, and economic cycles. We are living through a period of profound economic uncertainty. Recent years have shown that tariff impositions, changes in supply chain, war, political regime, climate change, and energy shocks can unsettle global markets far beyond their geographical region. These developments are symptoms of changing world order. Economic decisions are being made based on strategic considerations rather than commercial logic. In such an environment, financial markets have become highly sensitive. Many enterprises today operate on thin margin, debt-driven financing, and globally integrated supply chains. Any sharp correction in market can destabilize viable businesses. The truth is, in an interconnected world, insolvency is not an anomaly. It is a risk assumed within the global economic architecture itself. During the COVID-19 pandemic, a virus originated in one country but affected the entire world, including people in distant rural India who had no connection with outside world. Similarly, exceeding tariffs imposed by the President of the United States affects shrimp farmers in India. The undeniable fact is, in an increasingly globalized world, even the common man faces the music of faraway global events. This reality has compelled us to rethink our understanding of insolvency. Modern insolvency law seeks not flesh, but resolution, not retribution, but renewal. Therefore, the insolvency frameworks must be responsive, adaptive, and sensitive to these shocks. Businesses in India have consistently flagged concerns relating to over-governance, regulatory multiplicity, excessive compliances, and procedural delays. Over the past decade, attempts have been made at addressing this. At the same time, Indian judiciary's approach has remained anchored on the fundamental principles of upholding rule of law. The judiciary has balanced efficiency with the conscientious promises. Due process is an essential feature of our legal system, which cannot be discarded for the sake of speedy conclusions. We must remember that investors' confidence is sustained not merely by speed or flexibility, but by fairness, consistency, and institutional credibility, which are possible only if due process is followed. In this background, in the year 2016, India adopted Insolvency and Bankruptcy Code to provide for effective resolution of financially distressed businesses. It was a decisive shift in economic governance. Broadly, the results have been shown that IBC has led to a genuine value discovery through competitive market processes. According to the latest quarterly reports published by IBBI, during the financial year 2023-24, 269 resolution plans were approved, the highest number since the inception of this code. Nearly 40% of the companies resolved under the IBC were either defunct or earlier struck before BIFR. These cases have led to recoveries of around 155% of the liquidation value. 308 corporate debtors were rescued through early settlements, withdrawals, and negotiated exits, showing positive impact of the IBC on debtor behavior. An independent study of IIM Ahmedabad examined firms post-IBC resolution and found significant improvement in profitability, liquidity, turnover, and operational efficiency. Now, we have to see that how IBC has contributed to the stabilization of the banks and its economy. There have been significant gains for banks as well. For decades, Indian banks were weighed down by mounting non-performing assets and prolonged recovery process. The absence of a credible exit mechanism meant that stress accumulated silently on the balance sheets, thereby impairing the ability of the bank. The IBC has also made some improvements in this sphere. One, the code has improved credit discipline through strict timelines. It puts creditors in control, which is a strong deterrent for borrowers. The IBC has helped banks to clean up their balance sheets in a structured and transparent manner. Finally, at a macroeconomic level, the IBC reinforced confidence in banks, in markets, and in business. Now we have to look into the experiences of the 10 years of IBC. To ensure the goals of the IBC are fulfilled, we must keep evaluating and reassessing working of the code. The last 10 years has been numerous amendments, judgments, discussion papers, etc. In this background, I would like to highlight a few more areas that can be improved and optimized. The IBC is still struggling to provide speedy and time-bound resolution of corporate debtors. The ground reality is that 330 days timeline for concluding CAIRP is being stretched to 600 to 700 days. The time for admitting insolvency applications has stretched to several months instead of 14 days. Why the timelines are not being met? The answer is simple but bitter. Legislative provisions alone cannot remedy the delay. In fact, legislative timelines can sometimes become unrealistic. The time period for resolving a company with a turnover of 10,000 crores cannot be the same for a company that has a turnover of 10,000 crores. So, while assessing timelines, all corporate debtors and situations cannot be treated as the same. We must recognize that our economic landscape is shaped not only by large corporations and institutional creditors, but by micro, small enterprises, informal workers, etc. Having said that, it is also true that the number and complexity of insolvency disputes have steadily increased, but institutional capacity has not expanded proportionately. Presently, nearly 7,000 IBC cases are pending across various NCLT benches. Even after 10 years, we are still discussing the issue of shortage of NCLT members. I am told that currently NCLT benches in Delhi hold court for only half a day due to lack of courtrooms. The government needs to address these infrastructural problems on a war footing basis. During the hearing of Swiss Ribbons case before the Supreme Court, the government assured that they will create NCLT benches across the country within a period of 6 months' time. But they have created only one bench in Chennai. But the workload is so much. What about Mumbai? What about Hyderabad? What about Calcutta? The decision to establish circuit benches should be based on the volume of the litigation and not other consideration. This is the most important thing which the government has to take care. Another aspect that needs immediate attention is the qualification, training and service conditions of NCLT and NCLAT members. The present qualification of technical members permits any person with 15 years of professional experience to apply. I will give a personal example. When I am interviewing in Mumbai, these NCLT technical members, all the other members who appeared before me, they came with some jacket and all that. They are talking in English, answering the questions. One gentleman came, I am not blaming or anything, he came with dhoti and all that with a small jute bag. I was surprised why he is there. So I asked, why you are here? I came for an interview. This is what he said. You are expert. Yes, I am running my kirana shop from the last 30 years. My experience is they want only 15 years experience. So I am also eligible to consider the NCLT technical members. This is how the situation is there. So there must be some stricter guidelines to apply for the technical members particularly. So the pool of consideration, only meritorious candidate, timely appointments has to be made. I will not try to say here that the position of technical members cannot become an asylum for former bureaucrats. Of course, there have been some instances of technical members that have authored excellent judgments. Madam Sirisha is here as a Chief Justice. I have seen her wonderful judgments, and even though she doesn't have any experience as a business and all that, but she wrote a good judgments. And several other members who who came from the lawyer community, take for example your Badrinath, they have written very good judgments, even though they doesn't have much experience in the adjudication and all that. So there is no problem. That's why while selecting we have to choose good people. Then only the things they can be delivered. So the common experience of the bar that new members take several months to understand the working of the IBC. Thus, intensive training of members is required not only at the time of appointment but continuously during their term of service. Another important thing is that service conditions of the members. There is an urgent need to create a cadre of NCLT and NCLAT members instead of tenure-based appointments. We need assured job security and proper facilities for members. The position of a member needs to be recharacterized from a post-retirement position to a meaningful career path. Because if you give 4 years, 5 years tenure for a member, and after that he has to retire and no good advocate, no competent chartered accountant, no person had good knowledge will come for these jobs. It is a tenure post, nobody likes to work for 5 years or 4 years. So it is better to create a service oriented jobs. So the quality, training and professional maturity of insolvency professionals, advocates and valuers is also critical. This will create a meaningful insolvency ecosystem. Insolvency matters must begin with the clear understanding that insolvency law is a process-driven economic legislation. Its effectiveness depends less on individual judicial discretion and more on creditors' commercial wisdom, certainty, timelines and predictability. Judges and adjudicators must therefore adopt an attitude of principled restraint. This is true not only for insolvency law but broader commercial litigation and arbitration. In this regard, the jurisprudence of the Supreme Court has consistently underscored on the central principles that 1. The success of the insolvency framework depends upon the minimal judicial interference. 2. Insolvency is not an adversarial litigation but a collective resolution mechanism. Strengthening insolvency tribunals and insolvency law is not a matter of convenience or knee-jerk reactions. It is prerequisite for preserving the rule of law in economic governance. After all this, I reminded the famous lines of Charles Dickens in Tale of Two Cities. It was the best of times, you all must know. It was the worst of times. It was the age of wisdom. It was the age of foolishness. It was the epoch of belief. It was the epoch of incredulity. It was the season of light. It was the season of darkness. It was the spring of hope. It was the winter of despair. The current state of affairs shows the above Charles Dickens description in Tale of Two Cities. What I want to say ultimately is there is a need for clarity by the authorities and the government. The current state of affairs shows that the initial zeal and enthusiasm with which the code was introduced has now faded away. We are seeing the tribunals is crippled with staff vacancies, insufficient courtrooms and other infrastructural challenges. The authorities appears to become complacent now because the bad debts have been erased from the balance sheets of the bank. Sorry criticizing this is the reality. However, I hope that the IBC is still a baby legislation of 10 years old. Ups and downs is normal for a economic experiment. However, the IBC is set to mature and we must iron out the creases. As we see them, we cannot ignore them. I have been told that some of the points raised by me have been addressing in the future amendments, which is going to already laid in the parliament. Yes, sir. It is already laid in the parliament. This reflects the conscious effort of to address the implementation and challenge of to refine the IBC. The move forward, stricter admission timelines, greater procedural delay clarity, reduced scope of tactical delays seeking to restore the original promise of time-bound resolution. The introduction of pre-packaged insolvency for medium and small enterprises acknowledges that these businesses require faster, less adversarial and cost-effective resolutions mechanisms. I am hopeful that the upcoming budget also give infrastructural push to the NCLT and CLAT members, which is desperately needed. The way forward, therefore, is not radical reinvention, but institutional course correction. Dialogue, research, and reflection are essential to responsible reform. I commend the Insolvency Law Academy for fostering these conversations and for contributing to the evolution of insolvency law in India. I wish the conference is a grand success. Thank you once again for giving this opportunity.
May I now invite Vedhi to present the vote of thanks.
Honorable Chief Guest, Justice N. Ramanna, Guest of Honor Mr. Mark Bloom, distinguished dignitaries, respected speakers, delegates, ladies and gentlemen. As we come to the conclusion of this opening session of 4th Annual Conference, it is my proud privilege to propose a formal vote of thanks. At the outset, on behalf of Insolvency Academy, I wish to express our deepest sense of gratitude to our Honorable Chief Guest for gracing this occasion with his august presence. Your invaluable insights, inspiring words, and thoughtful perspectives have not only enriched this opening session, but have also set a clear, purposeful direction for the sessions that will follow. We are truly honored by your time, guidance, and encouragement. The Insolvency Law Academy is immensely proud to host the 4th edition of this annual conference, making yet another year of sustained dialogue, collaboration, and commitment towards strengthening the insolvency and restructuring ecosystem. This continued journey would not have been possible without the collective support and trust of all our stakeholders. We place on record a sincere appreciation to our powered by sponsor State Bank of India, whose generous support has been instrumental in making this conference a reality. We also extend a heartfelt thanks to our associate sponsor, National E-Governance Services Limited, Maximus ARC Limited, and Chambers of Ishnakumar for their valuable and continued support. A sincere gratitude goes to our global media partner, Global Restructuring Review, and for providing this conference with an international platform and helping us reach a global audience. We are equally thankful to SEC Times, our media partner, for their consistent promotion, coverage, and support, ensuring that the impact of this conference resonates far and wide. A special word of appreciation is due to, of course, my team, Ms. Shivani Sahu, Ms. Sumant Batra, Ms. Pranita Raj, Ms. Vandana, Ms. Khushbu Khan, Mr. Dev Batra, and of course Sandeep Sani, along with the volunteers we have here, who have tirelessly worked behind the scenes to make this happen. We also extend our sincere thanks to all the delegates and participants for your presence, active engagement, and a thoughtful participation. Ladies and gentlemen, with this, we formally conclude the opening session, and thank you so much for your presence. Now we'll have a 20-minute tea break, and then we'll reconvene with two technical sessions. Thank you so much, and have a great evening. Thank you.